Daily cost list, item number 1 for pronouncement of judgment.
So I'll read only the operative portion.
Yes, sir.
It's a half and half judgment. For you, against you, similarly for you and against you. In view of the above observation, this court would hold that the impugned order cannot be faulted, except to the observation and finding at para 53 of the same, which under the circumstances could not have been observed or concluded without evidence being led in that regard. This part of the impugned order is struck off. The parties are directed to participate in the trial and no prejudice will be caused to the petitioner if he is allowed to challenge the validity of the said sanction during the trial.
May I please, Your Lordship? The move mentioned, my Lord, for tomorrow. There is some urgency, my Lord.
What's the
My Lord, here what happened, my Lord? There was a patta.
case before this court?
No, my Lord. It's a fresh case, my Lord. I'm coming under 482, my Lord, for quashing of an FIR, my Lord. There's urgency, my Lord, because I was picked up by the police. I was produced before the court. Court has granted me bail, my Lord. Subsequently, again, cancellation of bail has been filed by the police. It is the police who are doing all this, my Lord. Basically, I'm the officer of the district council, my Lord. There was a civil dispute before my office, my Lord. Prior to me holding that post, my Lord, and a patta was issued in favor of X person, my Lord. Y has filed an FIR. On the basis of that, I was picked up by the police, my Lord. For that, my Lord. Tomorrow, my Lord.
My Lord, I beg to crave my Lord's indulgence. There's one very urgent matter, my Lord. In fact, the matter was listed before Justice Thank You today as item number 3, my Lord, in the motion. There's a tender, my Lord, which is the bid that is going to be open today at 3 p.m, my Lord, as per. This pertains to supply of lightning arrestor system, my Lord, in a defense establishment, my Lord, in the Assam Rifles, my Lord. Now we were aggrieved by certain clauses of the bid agreement. We filed the first round of litigations, my Lord, before Justice Thank You. Thereafter, 22 clauses, conditions were changed. However, we were aggrieved with one of the conditions which says that experience of 2 years, and they say that it's just only a generic, therefore it's okay. But it is not so, my Lord, because this is a very highly technical matter which involves life and security of the properties and also lives, my Lord. It's something like lightning where we control the lightning, my Lord, and it's such a high-end thing. So, my Lord, in view of this, my Lord, I pray, my Lord, this matter, my Lord, may be pleased to take up. We just need protection for 1 day, 2 days, so that, my Lord, before my Lord.
We're going to your speciality.
My Lord.
As far as technical bit is concerned, it would have been considered, giving all parties an opportunity.
My Lord, Learned Senior is here, my Lord.
The matter was heard on Friday, my Lord. They could not make out any case, my Lord.
It's
thereafter what happened, my Lord, they were trying to place some additional documents by passing on to the Honorable Court, my Lord. The Honorable Court said that you file a proper affidavit, we will not accept papers just like that. And the matter is listed before Justice Thank You's bench today. There is absolutely no merit otherwise also, my Lord, and the matter can come tomorrow, then nothing is going to happen in 1 day.
My Lord, additional affidavit was allowed to be filed by His Lordships, my Lord, and we have filed the additional affidavits, my Lord, and it is on records, my Lord, and we have served an advance copy to my to the respondents as well, my Lord. And now, whether there is a merit or not merit, my Lord, that is my Lord's for my Lords to examine, my Lord. Now, therefore, my Lord, what I'm only craving, my Lord, is that, my Lord, may this matter come up at the end. We just need a protection. Otherwise, it becomes infructuous. At 3 p.m., they're going to open the bid, my Lord. And we are saying that they are trying to favor some bidders whom their favorites, my Lord. And they are trying to bring in such a way that clauses in such a way that which will suit the favorites, my Lord. This is what we are saying, my Lord. And, my Lord, this is it's apart from, my Lord, security to the life in security to the forces, my Lord. It's also security concern of the nations, my lord.
This is not PIL, my
Now,
lord.
but how would that,
Of course.
They are not the one who will determine what is
how would that
good for national
affect
security,
you?
my lord.
How would it affect you or affect the process for that matter?
My lord, once it is opened, my lord, it is opened, my
Once
lord.
it is open,
Then
only
this become infractures, my lord.
only a party who is competent and qualified in all respect will be allotted.
That's only we want.
I'm sorry, my lord.
Once the bid is open, only
Yes,
those,
yes.
only any party who is qualified
Yes.
or who is competent will be accepted.
My lord,
Not a
that is,
question of being qualified or
my lord, that is not, that is their intent, my lord, not to give to a qualified person, my lord. The way they have
How do
scaled
they
down,
know, my lord? The
My lord,
bids are still in online in the cloud, my lord.
my lord,
How
the
do they
way
know?
they have, my lord,
And we don't even know
they
whether
have-
they have submitted their bid or also not.
they have scaled the very fact, my lord. Kindly look at this sequence, my lord. They say the bid says that in 4 days you have to dispose of our representations. They have never disposed of our representations until we file a writ, my lord. Then only they came down and they dispose of representation, changing 22 clauses, my lord. One or two clauses also are understood,
so we'll take it up.
my lord. I'm so deeply obliged, my lord. My lord.
My lord, the only difficulty, my lord, because the matter was supposed to be listed, because it is already there in the cause list, my lord. I informed the officers of the department to come at 2 o'clock, my lord, because the cause list was indicating 3 o'clock time, my lord. Now suddenly to call them with files, my lord. If lordships to take up at 3 o'clock, then, my lord.
My lord, whatever records that we have, my lord, in our disposal through this thing, we have
No, I
served them a
indicate
copy to them, my
I
lord.
have to indicate my records, my lord.
If they have to indicate by the recorder, they'll have to file a proper affidavit in oppositions, my lord, so that we also
how
get
can
an
my friend
opportunity.
stop me from
My
showing the
lord,
documents, lordship?
my lord, in order, but I'm so obliged, my lord.
Fine.
Because this was unforeseen for me, my lord.
If
As per
we'll
cause
take it
list,
up, we'll take it up at 3 then.
3, my lord. 3. Very well, my lord. I'm so deeply obliged.
The court, if by that time has
My lord.
finished its business, will reconvene at 3.
My lord. My lord. Deeply obliged.
Oh, may I please, your lordship, item number 7, my lord. Today I am not in a position to take up this matter. It may be adjourned for any convenient date, my lord.
You are for?
I am for respondent, my lord.
I'm for the petitioner, my lord. I'm for the district council respondent, my lord.
Yes, sir.
Yes, my lord, short date may be given.
Yes.
1
2
week?
weeks, my lord.
1 week?
Yes,
Yes, my lord.
On premiere by the respondent.
yes. For state respondent.
You have
State respondent, my
state,
lord.
oh, you're state respondent.
Yes, my lord.
Okay. I thought
No.
Private
Mr.
respondent.
Dev?
I'm for district council.
this is counsel. On premiere by Mr. A.H. Hajarika, learned GA, appearing for the state respondent, seeking accommodation on personal ground, and the same not be objected to by petitioner. Matter is adjourned. This is same after 1 week.
Yes, obliged. May I please, your lordship, item number 8 also, my lord. Here I am the petitioner, my lord. After a week, my lord, it may become.
Yes, who's for the
Respondent. Number 8, my lord.
for the state
Yes, your lord.
on premiere by the petitioner, and this is matter after 1 week.
Yes, my lord. Much obliged, my lord.
May it please your lordship, I beg to mention item number 13. The hearing is. For the state respondent.
I'm for the petitioner, Your Lordship. No objection.
On premiere by the state respondent, not objected to by petitioner. This is matter after 2 weeks.
May I plead, Your Lordship? I beg to mention item number 14.
Yes, who's for the respondent?
Respondent.
Respondent number 2, madam.
What is this matter about?
It's about section 145, Your Lordship.
Then why?
The senior conducting counsel is not available, Your Lordship.
Those matters could have been disposed of on pre-made by the petitioner. This is matter of 2 weeks.
Much obliged, Your Lordship.
Please, Lordship. Lordship, I beg to mention for item 5, Lordship.
Your phone?
I'm from petitioner, Your Lordship.
2014 matter.
Yes, Lordship.
This court has time and again indicated that the
Yes, part heard, Lordship.
indulgence will not be allowed.
But as per last order, that the instruction that we have got from our client that there is no outcome from the respondent, Your Lordship, that they said that they'll pay their salary.
Or that
Salary, pending salary. Lordship, I inquire, I have to seek instruction. So, Lordship, I need some time, Lordship, will set a meeting, the present MC, because that money has been pending with that then secretary who died, Lordship. So that money, they're willing to adjust, Lordship, just 1 week time, Lordship. Let them settle in the
yes,
meeting.
I think this court has indicated.
Yes, yes.
If the petitioner is entitled to, then
Yes, Lordship.
give.
The
See, what
present-
happens is you have to accept prima facie.
Yes,
It is the secretary who has misappropriated the.
yes, who has
Now he is
expired.
gone.
Yes, Lord.
Nothing can be said about it.
Now only the adjustment, how to arrange for that 9,500. If they're willing to pay, Lordship, but that they've informed me willing to pay, but only for arrangement of that money, Lordship. But the present MC, they have to bear all the expense.
2 weeks, Your Lordship.
Learned counsel for the parties have submitted that, and the learned counsel for the respondent number
10 to 14.
10 to 14, the managing committee has submitted that efforts is being made by the managing committee to pay whatever is due and entitled to by the petitioner. However, this exercise could not be completed and some more time is required for the same, even to the extent that the petitioner would agree to the proposed repayment of her dues as paid for by the parties. This matter will come up again after 1 week.
2 weeks.
2 weeks.
Oh,
So, similar prayer for item 6, Your Lordship. Lordship, in this matter, the respondent for file an affidavit. Lordship, we have received a copy, so we'll be filing the rejoinder, Your Lordship, in a week.
When have you filed? Who is respondent for?
It's me.
When have you filed it?
I filed on the last date.
To bring on record those documents?
Yes, those archival documents, Lordship. They've prayed for the file rejoinder.
We'll file rejoinder, Your Lordship.
1 week's time will be given to you. It is submitted on behalf of the petitioner that the rejoinder to the affidavit filed by the respondent 4 could not be filed today and some more time is sought for the same. As prayed for, the petitioner is to file the rejoinder within the next date fix. This is matter after 1 week.
Only obliged.
May it please your Lordship. Lordship, I beg to mention item number 10. This is a joint prayer, Lordship.
What is item 10?
My Lord, this is with regards to the dismissal from on the ground of ADS, my Lord. On medical ground it has been dismissed. So,
Lordship, we were supposed to file written argument in this matter. Lordship, some more time may be granted.
Oh, written argument. Have you filed yours?
no, my Lord, I will file it.
Lordship, some more time may be given.
On prayer made by the parties to file their written argument. Matter is adjourned. This is after 2 weeks.
3 weeks, Lordship.
2018. 2 weeks or 3 weeks?
3 weeks on.
3.
3.
Lordship, similar prayer for item number 11.
You are there?
Same, my lord.
Same order?
Same order.
This also for
For ADS.
Same order. Huh?
Thank you, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention on item number 12. Lordship.
So it's taking you so long to file the written argument? You have filed yours.
Already filed, Lordship. Three
File
months
within the course of the
back,
day, Lordship. And make sure it's filed within the course of the day.
Lordship has indicated in the last occasion that it should be a last chance today.
Yes, so?
Filed within the course of the day, Your Lordship.
Learned counsel for the respondent has submitted that the argument could not be filed in time. However, it is submitted that the same will be filed in course of the day. Accordingly, this matter on Friday. File it today, and then matter will be taking cognizance of on Friday.
Lordship, I beg to mention one matter for unlisted motion today, Lordship, concerning it's an anticipatory bail, Lordship. My bail has been rejected from the trial court on 21st/7. So we are apprehending arrest, Lordship. Some urgency. It's already been filed, Lordship. It's already registered. Today, Lordship.
May it please Your Lordship, in fact, Lordship is a POXO.
So,
going by the version in the FIR, Lordship, it appears that the boy is already married.
It's a love relationship, Lordship. Lordship, if kindly take up the matter at 3, Lordship, if possible.
Why?
Lordship.
At 3.
Lordship, I beg to mention item number 15, Your Lordship.
What is this matter about?
482, my lord, for quashing your FIR. It was between two brothers. Your lordship is already on the last occasion. So efforts are on. From my side, I have said that I am ready.
Lordship, we are trying for a settlement, Your Lordship. Settlement, Your Lordship. Trying to go for settlement, Your Lordship.
Have you made any effort? Have you?
We'll try, Your Lordship.
This matter has been there for quite some time.
Yes, well.
This court has indicated, in fact, the parties have indicated that they are willing to settle the matters. It is practically a fight between brothers.
My lord.
So, what's taking you so long?
From my side, I am ready, my lord. It's from their side that they have to take the initiative.
What are these sections involved?
My lord, it's all assault matter. Basically, it's assault.
323 or 325?
25,
26.
26. C26 506 34, my lord.
So how long?
It's up to them, my lord. I'm ready anytime.
2 weeks, Your Lordship.
The counsel for the petitioner has submitted that an effort will be made for an amicable settlement between the parties involved, and for which some time is prayed for, indicating that if and when the settlement is affected, there would be no reason for the proceedings to continue as far as the parties are concerned. On prayer made, the same is allowed. This is matter to 2 weeks.
All right.
Item number 2.
May I please, Your Lordship? Your Lordship, this is bail under NDPS Act. Here, Your Lordship, the petitioner is the father of one of the accused, Muhammad Masum Ahmad Chaudhary, who is 20 years of age. And on 12th February 2023, information was given to the police that he has been kidnapped, and he was kidnapped for ransom. And accordingly, the police somehow would rescue my son. And thereafter, it was alleged that some contraband was recovered, which was handed over by me to my son to the other accused. This contraband was recovered from a local taxi, where these kidnappers they use this vehicle for kidnapping. So accordingly, Your Lordship, I was arrested on mere statement of one of the co-accused that this contraband 15 grams of heroin was delivered by me, whereas I was kidnapped for ransom, and charge sheet has also been filed against the kidnappers. So save and except the statement of the co-accused, there is no other material. And Your Lordship, section 25 says that statement before the police is not admissible, and there is no proper section.
Not admissible
in evidence.
In evidence.
Yes, Your Lordship.
During trial.
Yes, Your Lordship.
Not for the purpose of
yes, Your Lordship.
of filing a charge sheet.
Yes, Your Lordship.
Or coming to any prima facie
yes, Your Lordship.
Findings.
Yes. So now I have been in custody for the last 5 months 20 days. Charge sheet has been filed. Charge sheet was filed, Your Lordship, within 45 days. Of course, now they have submitted the FSL report also. So I'm not going on to all those technical. I'm only praying, Your Lordship, that since I was kidnapped, and there is prima facie evidence also that I was kidnapped, so there is always possibility that, Your Lordship, they have the other co-accused, they have implicated me just so that they will evade involvement in the case. So only that is the only prayer, Your Lordship. I am 20 years of age. Yes. And 15 grams.
My lord, here the facts are completely different from what my friend has stated here. Actually, what had happened in this case, some 5 people goes to Assam for collecting drugs, and the person who is alleged to have been kidnapped was the peddler involved. So after delivering, when he demands for money, then the 5 of them gets agitated and drags him in the car. That is the story. Now, my lord, that apart, the twin conditions that needs to be satisfied to consider a bail application and NDPS laws. The first condition is that whether there are reasonable grounds to come to a conclusion that petitioner is innocent. Second, lordship, with
that is 37.
2B.
37.
Of course, that is not the case here. It's a case of slightly higher than the small quantity, and is
intermediate.
So therefore, lordship, here he is the peddler. So definitely, if he is on bail, he is going to continue with the offence. This is not the first time he has done this, and all the statements of the witnesses.
Charge sheet have been filed.
Yes,
it has been filed.
What is the stage of the case?
It is for evidence. It is fixed, not even a single witness has been examined yet, but it is fixed for evidence on 10th of August. But Your Lordship, my senior has said that I am not the first. There is nothing, Your Lordship, that I had any criminal antecedent, that I was involved previously also. I am 20 years. I have not been. There is nothing in the charge sheet that I was involved previous or I have peddled any type of drugs. So only on the basis of the co-accused that. And my senior has also stated that it was alleged that but in the charge sheet only they have said that I was kidnapped. In fact, in the FIR, Your Lordship, page number 10.
What is the evidence against him? What is the evidence against him?
My lord, the 5 co-accused were examined, and they have stated very clearly in no uncertain term, saying that they regularly collects and he is the paddler. So it is not a case of kidnapping per se, but it was some misunderstanding took place between the this paddler and the one who went to collect. So that was the reason why he was being dragged.
Is there any nexus between those person and the accused person here?
Yes, they
CDR,
were into transaction.
Any CDR?
Yes, the CDR has been analyzed, and it was found that they were constantly in touch.
Is it?
It is here. Lordship will come to page number 27. Page number 27.
Yes.
Yes. The last part. Call details record analysis is of the petitioner here.
Petitioner son.
Petitioner son. Lordship will come to now page 28, the last part. Observation. CDR analysis of mobile number so and so, which is registered and used by Muhammad Masum Ahmad Chaudhary, revealed that he is in contact with the kidnapper Sri Bajab Shuklan until his arrest on 12/2/23. They were constantly in touch for delivering the contraband. Now CDR analysis of this Bajab Shuklan is at page 26. Relevant portion will be last part of page 27. The findings. CDR analysis of mobile number so and so, which is used by Bajab Shuklan, revealed that he is in contact with paddler Sri Masum Ahmad Chaudhary until his arrest on 12/2/23. So there is a clear nexus.
You say that you don't know these kidnappers?
No, Your Lordship. I was kidnapped from Sonapur, and this mobile phone was also with them only, Your Lordship. I was kidnapped, mobile phone was with them only. I don't know how they have dealt with this mobile, but prior to that, if they can show that I was
it is registered in his name.
No, I was kidnapped, so obviously the mobile phone also will be with me only, with the kidnappers only, and they will not allow me to contact, or they might have contact with each other. So only I am not going on technical.
Pass the order.
Yes.
Heard Mr. S. Pandit, learned counsel for the petitioner, who has submitted that the petitioner is the father of accused person,
Muhammad,
namely Muhammad Masum
Ahmad Chaudhary.
Aged about 20 years, who was arrested in connection with Cleariat PS case number 10/2/2023 under section 364A capital A oblique 34 read with section 21 under bracket small b oblique 29 NTPS Act. The learned counsel for the petitioner has briefly narrated the sequence of events to say that the son of the petitioner was allegedly kidnapped by a group of persons when he was, what was he doing in Sonapur?
Sonapur, Your Lordship, his father business is there, like truck. He used to operate truck.
When he was at Sonapur, the place where
he was managing his father's business.
That is, the petitioner herein was doing business. So he was allegedly kidnapped and then he was found.
Yeah, police rescued him.
Police rescued him.
Yes, yes. From he was rescued, Your Lordship, in page number 10 only, the police only they have stated. At around one Masoom has been kidnapped by unknown miscreants around from Sonapur area and taken him towards Lumsnong Kheriat. They kidnapped him 2 vehicles. One vehicle particulars were given as auto bearing numbers, another white color van. Immediately I informed my senior officer who alerted the entire district police force, and at around 4:30 OC Kheriat and his team were able to rescue the kidnapped person Muhammad from Kheriat area, Rimbai bypass near road near old DC office.
Last line. On 12/2/2023. However, the police have soon apprehended the alleged kidnappers who were traveling in 2 vehicles and the son of the petitioner was accordingly rescued. Next, in course of investigation, the police have come to a finding that from the kidnapped person, that is the son of the petitioner herein, one soap box said to contain heroin was found. This too was on the leading of one of the main accused in the case. Accordingly, the police have registered a case under the NDPS Act, and amongst the arrested person, the son of the petitioner was also arrested. Next. In course of investigation, the investigating officer has come to a finding and on evidence being collected, on evidence being collected, the IO has come to a finding that there exists a prima facie case against the son of the petitioner, who was accordingly charge sheeted and directed to stand trial. The Learned Counsel has further submitted that the factual aspect of the matter is that the accused son of the petitioner is nowhere involved with the alleged recovery of the contraband substances and has no connection with the other accused persons who were arrested in connection with the said NDPS case. He was in fact a victim of kidnapping, but on the police apprehending the kidnappers, he was falsely implicated in the case. the accused person being in custody for almost how many months?
5 months, 20 days.
5 months, 20 days. He is therefore prayed that this bail application may be allowed and that he may be enlarged on bail with any condition that his court may be deemed fit to impose. Per contra, Mr. R. Gurung, Director GA, has submitted that the petitioner has not depicted the accurate picture of the case, inasmuch as the accused son of the petitioner is a drug peddler, and in course of his business dealings with some of the co-accused person, perhaps relating to monetary exchange or consideration, he was not being paid as he has demanded, for which he was kept in the custody of the accused persons, other co-accused person.
My lord, if I may, he himself has revealed this while during the interrogation. Is it page 20?
What did he say?
He is saying here, during preliminary interrogation, all the accused person it was learned that the kidnapped victim Muhammad Masoom Ahmed Chaudhary in fact delivered one soap box of heroin to accused person who kidnapped him after taking delivery of the drugs. Accordingly, Muhammad Masoom Ahmed Chaudhary was arrested, and during interrogation, he revealed that he was handed over one soap case of heroin by one person, Sri Kabir Barbhuiya of Karimganj at Tongseng village, and to asked him to deliver to Sri Bajak Shuklan. He revealed that.
Yes, I think that has gone. Yes. That he has a connection with the other co-accused, and allegedly the heroin was,
delivered by
was recovered from his possession. He was not being paid. However, in his however, the IO in his investigation has found out that the accused son of the petitioner has admitted that he was handed over the said contraband substance by one person who is a resident of Karimganj at Tongseng village, and he was to deliver the same to another co-accused in this case, that is Sri Banjab Shuklan. Thereafter, after handing over the said soap box to the said co-accused person, and on payment being denied to him, he was forcibly dragged inside the car. Hence, the allegation of kidnapping. It is prayed that it is submitted that there is the learned G has further submitted that there is clear evidence of the connection of the accused son of the petitioner with the other co-accused, inasmuch as there are call detailed record available which will show that the accused son of the petitioner is in constant touch through mobile phone with the other co-accused, particularly Shri Banjab Suklin. It is therefore appropriate that there is no merit in this case and the same may be dismissed. On consideration of the submission made, what is to be noted here is that the case has been charge sheeted, and as such the submission of the petitioner on behalf of his said accused son is to be based on merit. Prima facie, on merit, there is no prima facie on merit. It is seen that the said alleged contraband substance was recovered from the accused son of the petitioner, and that he also has a nexus with the other co-accused person said to be involved in the case of kidnapping as well as in the case of drug possession or peddling. Given the seriousness of the case and the gravity of the offence, at this point of time, this court is not inclined to concede to the prayer made by the petitioner. Accordingly, this petition is hereby dismissed as devoid of merit.
Item number 3.
May it please Lordship. Lordship, in this case, I filed an application under 482. 482 before, and the order is in page 79. After hearing the petitions of 482, where I have claimed that regarding the speedy trials and day-to-day trials is not happening, and according the court has dismissed my applications, but liberty was given to me in para 11. He said it would be open for the accused person to prefer an application for bail if so advised. That is the application. I have no choice. I have filed bail applications, and this bail application which I filed, the accused person herein is charged under section 27 only. 27 only. Now the case was registered sometime in the month of June and July. 2 cases were registered. As per the (27) speaks about the conspiracy.
27 or 29?
29, Lordship. I'm very sorry, Lordship. 29. 29 is a punishment for abatement and criminal conspiracy. Whoever abates or is party to the criminal conspiracy to commit the offence punishable under the chapter shall, whether such offence or be not committed in consequence of such abatement or in pursuance of such criminal conspiracy, notwithstanding anything contained in section 116 of the Evidence Act of the 116 of Indian Penal Code, be punished with imprisonment provided for the offence. This is the section I was charge sheeted under the section 29 only. Lordship, this is the case. The FIR was registered. The 2 cases registered, 2 different accused persons. Annexures 1, page 17 and page 18. These are the 2 FIR registered. One is registered in the month of June and one is registered in the month of July.
Yes.
So in this FIR, nothing is mentioned that this drug was supplied by me. And the case was registered under section 64(1), under section 21C, 22 and 29. Some of the accused persons were arrested in this case. 7 or 8 accused persons were arrested. And the matter was investigated. Then second FIR also was filed in different case of recovery, where the case was registered as Caleriad PS case number 65-7-2022 under section 21C, 29 and DPS Act. 3 accused persons were arrested. Now my case is that at that point of time, the contraband was not recovered from my positions. The question of section 54 of the NDPS Act doesn't arise. I mean, presumption will not arise because no contraband has been recovered. These people were arrested in the month of June and July. Now, the day when I was coming from Silchar, from Manipur, to appear one of the NDPS case pending here in the Shillong on 27. So I was coming by night super bus. In the meantime, I was intercepted, interrogated. The police did not find any contraband goods from me. And even the police has arrested me and taken to the police stations. Thereafter, medically examined. On 27, I was formally arrested. There was no evidence collected by the police. Now, during the course of the evidence, there also after June, I was arrested on 27 October 2022, after more than 2 months. The only evidence police are saying that I have an evidence that I was in touch with them over phone. I have gone through the handset, the SIM was not registered in my name. And there's no evidence to show that I made any call either coming from Shillong or from Caleriad. All the call came from the Manipur only. And I am not the registered owner of the SIM. Maybe some other person might have been used it. On that ground, the police has charge sheeted the case, and even then we move a successive bail application before the learned trial court, and it was rejected. But the case now it is going to be 9 months, 3 days. We pressed that argument before charge to be taken place, but because the FSL report was not submitted, CFL report was not submitted, the case was not proceeded. Even the court has observed that in the case that the court has directed even to proceed with the trial. But even the last occasion also the same thing happened. We appeared virtual mode and we press, and this is the last order passed by the trial court. Even the trial has not commenced, and there is no possibility of trial to commence even after the 9 months I have been there in the custody. And the offence which I am alleged is section 29, and based on the very weak evidence, there is a very important stage argument before charge. I can seek my discharge from this case, but it is not happening. Even if proceed for evidence also day-to-day basis under section 309, we can understand the case is proceeding very fast. Now, there is a case where there is no possibility of trial to be concluded very fast, and it is being delayed, though we are taking part in the trial. The evidence collected by the IO is only the handset which they seized after 2 months when I was proceeding to Shillong to appear one of the case. That time the mobile was seized, but it was not registered in my name. But police said I was in regular touch with the. But in the FIR, in other reports, the co-accused never said, never revealed, never took my name, that I am the person who was a supplier. They say one Didi from Manipur. Who is the Didi? So many Didi may be there. So for that reason, there is a reasonable ground to believe that the accused might not have committed the offence as alleged by the police. And the evidence which is, I have already enclosed a copy of charge sheet. In view of, if I rely some judgment, recent judgment of Supreme Court regarding the reasonable belief, because the Supreme Court has, in two of the cases, Supreme Court has granted the bail on this ground only.
That is on account of the the trial taking.
Trial taking also, and very recently also. This is the case, it is decided on 13/7/2023, citation, section 4. As regard to the twin condition contained in section 37 of the NDPS Act, the learned counsel for the respondent state has been duly heard. The first condition stand complied with. So far, the second conditions, formation of opinion as to whether there are reasonable ground to believe that the petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in the custody. The prolonged incarcerations generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution. In such a situation, the conditional liberty may be override the statutory embargo created under Section 37(1)(b) of the NDPS Act. So this is one of the judgments Supreme Court has held. But in my case also, because the situation is very funny, because if I am arrested on the same day, or after 2 days or 3 days, they found the location that I was in touch with the accused person supplying the drugs. But in this case, the accused from whose possession drugs was recovered were already in the custody, right from month of June and July. When I was coming to Shillong to appear in the case, then I was arrested on 27 October 2022. The gap, the delay, how much time the police took and arrested me without any basis at the first stage. Later on, they say that there is a CDR. In view of the fact that I'm already 9 months and the trial is yet to proceed, commence. Trial commence only when the charge is framed. Once the charges is framed, then trial commence. Then we can expect that under Section 309, day-to-day trial will be there and it will be concluded. But in this case, Lordship, kindly see the period, 9 months, 3 days, and the gap between the alleged offence and my arrest is all after two months. Lordship, this is a fit case. I humbly submit that.
So your main contention is because of the delay.
Because of the delay, and the Supreme Court, one of the conditions says, the second condition regarding the second conditions, the reasonable ground to believe the prisoner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years. So my case also.
That is also an issue of delay.
Delay.
Or
issue regarding, he talks about the delay.
Prolonged incarceration.
But it's a very interesting case. My arrest was after more than 2 months. And the accused were already in the custody. When I was proceeding, then I was arrested. So that is the reason I am a sufferer, Lordship, in the custody.
What does the charge sheet say about you?
Charge sheet. None of the witness said. Charge sheet in one of the page 62, there is my statement only. Otherwise, none of the witness said anything against me. Srimati Kim Nicole Khongsai, mobile number so and so, revealed that the supplier is in contact with the mobile number so and so, belonging to the Sri Grey Carnoyers transporter, accordingly made deal to supply sold illegal contraband at Jeribam to be transport peddler Shillong. When the peddler was arrested by Cleared police, call detail, record analysis. These are the analysis. But none of the accused took my name, that I am the person who supplied the contrabands. I mean, none of the witness associated anything against me. It is just is my statement only. The police, in fact, tried to make me as a witness in this case, which is also violation of Article 23. A person cannot be forced to be a witness against himself or herself. But that is the only evidence.
That is the matter of trial.
Trial.
You read this page 65, the bottom part. This is a statement of one of the co-accused. 65.
55. Before, if Lordship comes to page 46, Lordship, kindly see the statement made by this person Kari Kharnayor at page 46. Then statement of Shri Kemenlang Sabong, statement of Marvin Jirwa, Lordship. The submission that that has been advanced, that the name was never taken out, the name of the accused, that is not correct as per the record.
One lady from Manipur, Kim, Didi, that's why I'm saying that. That is the reason I'm saying that the co-accused said they had taken from one Didi. Didi doesn't mean myself. There is I'm saying that one, so I'm going through the statement. My name is not taken. This is one Kim, so many Kims are there. Didi, so many Didi is there. But who is the Didi? The police has not in fact investigated. Police did not go to Manipur and to find out some more person involved in this case. Police simply concluded the investigation and submitted a charge sheet, very half-heartedly manners, and that's what the police, how the police can get the person who is supplying from the Manipur. In fact, the police could have gone to the Manipur to investigate, to inquire, and to examine some more witnesses from the Manipur that she is the lady, she was the main supplier. The police had not done anything in this case. Police has just put the full stop. After arresting her, taken her statements, some statements and the mobile phone, CDR. That on that basis the case is concluded. Charge sheet is filed. So no more efforts were made by the police. In fact, to go to Manipur and to make some more inquiry and arrest some more people to find out.
So you were arrested in 2 cases.
In 2 cases, I was implicated.
Implicated and arrested.
In 2 cases.
Whatever. So both cases charge sheet have been filed.
Both the cases charge sheet has been filed. Okay. I was arrested in charge sheet filed.
So now you have come for bail in only 1 case.
2 cases.
Both
the cases. No, in both the cases, because in one case I was arrested, in another case I was shown arrest.
Yes.
I was shown arrest.
Petition, Your Lordship.
During the course of when I was in custody in one of the case, then the police has said
that is your story.
Shown it. I was shown arrest in the other case.
On the basis of the statement by the co-accused.
Co-accused.
Can you see page 14, Your Lordship? A single bail application for 2 cases.
That is a technicality, Lordship, but the case is that I was arrested in one case, subsequently I was shown arrest in both the cases. Now these cases cannot be separated. The facts is that I am the supplier, I am the Didi, and I am in touch with the mobile contact. That is the case only of both the case projected in the same manner.
Yes, Mr. What do you say?
May it please your lordship. Lordship, one thing I would like to submit is that there are two cases, a single petition, your lordship. Whether that would be entertained, your lordship. Two cases, a single petition, your lordship. In my humble and respectful submission, your lordship, a separate bail application ought to have been filed for each case, your lordship.
But I have highlighted the facts of the case, under what circumstances we have filed this.
But yes, if there are two separate cases,
yes,
can you come by a single application?
Lordship, in fact, for bail, there is no bar. In fact, because even oral submission also is accepted by the court. But in this case, because it is interconnected the case.
Okay.
Because I was arrested in one case, 65.
Connected with the same
type of allegations, and mobile number also same. They said I have used the mobile number, same mobile number.
The other co-accused are also same.
No, other co-accused are not same. Two different co-accused persons. So that is one of the technicalities.
But you have made your submission mostly in the second case.
In both the cases.
In
both the cases, because charge sheet of both the cases have been enclosed here. Charge sheet, FIR also of both the cases enclosed. Charge sheet of both the cases are enclosed.
Yes, please, Mr.
May it please your lordship. Lordship, from the record, it appears, your lordship, it is clear that the bail applicant, your lordship, she's a supplier, your lordship. She is a drug supplier, your lordship. Lordship, as I have pointed out, lordship, kindly come to page 46. The statement of those people which have been arrested by the police name the bail applicant as one of the drug supplier. Your lordship, her name, the statement say by Manipur lady by the name Kim. Lordship, the name of this bail applicant, your lordship, will find it at page 3, at paragraph 3 of the bail application. Her name is Shimati Kim Naikol Khongsai. Lordship, whether this name Kim, as mentioned by the co-accused, whether this is it is the name of the applicant or not, your lordship, that is to be seen during the course of trial, your lordship. Not at in my humble and respectful submission, not at the stage of concerning bail application, your lordship. This statement made by the accused person, your lordship, as seen in page 46, implicate, your lordship, the bail applicant, your lordship, of her involvement, your lordship, in the supplying of drugs, your lordship. This statement, your lordship, in my humble and respectful submission, your lordship, are admissible, your lordship, for the purpose to determine for grant or refusal of bail, your lordship. To that, your lordship, I would like to
just a moment, just to be clear, Mr. Kursi.
Lordship.
You say that she was, while coming to
Shillong,
she was
arrested.
So she was not arrested. She was not in custody in the other case.
No, she was not.
She was given bail.
She was given bail.
She was arrested on 26/10/2022, your lordship.
Then
intercepted on 26 while she was coming in the night super.
Yes. So when she was arrested on 22/10/2022, it is in connection with these cases. The other case.
Other cases.
But earlier to that, she was also implicated in this case number 9.
9 in the which is going on Shillong.
In that case, she has been granted bail.
Granted bail.
So you have come only for bail only in one case.
No, lordship. Their case is different. The year is different. Here also is appears to be 9.
So there are 3 cases altogether.
3 cases. That is 2019. The Shillong case is 2019, though it is 9, but it is 2019.
See,
and this is the case of 2022.
What Mr. Shulai said is, I think, it's correct. You are making it confusing for the court.
This fact ought to have been brought, your lordship, if she is involved in 2019.
Now you say there are.
I have already stated.
Now you say there are 3 cases against her.
No, I have already stated that while I was proceeding from Manipur to appear before the district and session judge,
which means that you were not in custody at that point of time.
I don't have custody. I was intercepted by the police.
Implicated in one case.
Implicated in 2 pending cases. Which was a pending cases.
pending cases where you are involved.
Yeah, the police has showed my involvement there.
Okay, shown arrest in one case, that's true.
Yes.
So the other case is also you have not been arraigned as a accused in that case. But shown arrest in 2 cases.
2 cases.
Okay. But you are actually involved in 1 case.
Which I am facing trial.
Which is right? That means you have been granted bail in that case.
I was granted bail. I am facing trial. Every date I used to come for that case.
That is beside the point.
So while I was proceeding to Shillong.
So there are 3 cases altogether.
1 case I am already only on bail.
That has not been stated.
Where is it?
I have stated.
Where is it?
I have stated.
I have not seen it.
I have stated. Synopsis also. Even in my synopsis also I said the accused.
No, forget synopsis are not.
No, here also I have stated. Immediately I'll find it.
In which paragraph?
Where is the 2019 matter?
The accused person in Shillong, special judge, has been facing trial. It is para number 3. The accused person, Srimati Kim Nicole Kongsai, resident of Jiribam, Manipur, has been facing trial in criminal NDPS case number 9 of 2020.
Okay, sir. 2020.
2020. No, I just before the special judge Shillong, she was appearing before the court.
So this is one.
From time to time. Now, second said the police at Kalariat registered a case being Kalariat case number. This was the case already registered. Name of the accused is given. Then we have said.
So in 6. Okay. So now she has been arrested in connection with Kalariat PS case number.
Kalariat PS number
64.
It will be more clear, Lordship, if it's
65.
Paragraph number 6. The accused Kim Nicole Kongsai, while she was proceeding to Shillong from her hometown, was intercepted by the police on 26/10/2022 and thoroughly searched, but neither any contraband goods was found nor any incriminating materials. But she was detained and taken to Kalariat police stations, thereafter medically examined by the doctor on 27/10/2022 at 3:05 am in Civil Hospital, Kalariat. Later on, the accused was arrested in connection with Kalariat PS case number 65 under section 21C29, which was 3 months old case without any basis and evidence. The accused person was informed by the police that she would be implicated in number of cases. However, the accused person denied her involvement in any of the case, and after more than 15 days, that was not immediately, after more than 15 days, the accused was implicated and shown arrest in another old pending case on 11/11/2022, being Kalariat PS case number 64 of 2022 under section 21C, 22A and 27/29 NDPS Act. After 15 days, the shown arrest. The police seized 2 mobile handsets from the possession of the accused person, Srimati Kim Nicole, white Caesar list number so and so. The accused person, Kim Nicole Kongsai, filed following bail application, which was rejected by the trial court.
So where is the charge sheet of 64?
Charge sheet of 64 is here. Page number 32 is the charge sheet of 64. And the
it ends in
page number 32.
And at page what?
Page number running page.
Yes, 32 to
32 is the with regard to the.
Come to the last portion.
Last portion. Last portion is page 65. Page 65. It said further during investigation it reveals that a criminal conspiracy was hatched.
67.
65.
65 is statement of the accused.
Yes. What are you doing?
65. I think 67.
67.
Yes. So this is with regard to case number 64.
64.
Now 65.
65. Thereafter, second charge sheet is enclosed, which is 65. The last
68, should be 68.
From page 68. Yes.
68, Your Lordship, yes.
This is the charge sheet. Very briefly they have written.
Where's the second charge sheet? Where's the operative part?
Operating portions, because I was given a copy from the court. In this way only I received the copy. And it said sent to judicial custody for recording the statement, and she admitted to
But there
have...
must be, see, that portion where the IO finds prima facie.
Prima facie, yes.
Where is that portion?
It is 77.
No, sir, the page indication is mistake, I think.
It is complete. Your is okay, I think. It's come to this one too. This one come to this one.
Not in 77.
Not in order. Your this is not in order.
This one. 79, Lordship. He said sent to the judicial custody. Further, during recording of her statement, she admitted.
No, that is
There is
this 65 has also been charged, isn't it?
Charged, both are charged.
But there must be that. See, there must be that portion.
One portion is.
Look at it. Let's compare again.
The copy supplied by the court I received in this manner only. I have the copy supplied by the court also.
See, if you look at page 67, last paragraph, last but two paragraph, it says under the above facts and circumstances, prima facie.
Prima facie under section 21C, 22A, 27A.
See, this kind of noting should have been present in the other case also.
Other case, but other case, the copy which is supplied by the court was half. Same manner I have already enclosed here also. So here also they say sent to judicial custody for recording the statement. She admitted to involve in illegal activities supplying drugs to the state, sending to the youth, mostly Shillong. And from cumulative facts and circumstances of the case, further corroboration of the recovery, the illegal contraband commercial amounts for possession of the accused persons. Prima facie case under section 21. Prima facie case under section 21C, 29 NDPS Act has been fully made out against the arrested accused Sri Penhoy Tongtudu and Sri Bentilang Mensung, and section 29 against Kim Nicole Khongsai, for which the undersigned sent them up to face trial.
Okay.
This is given. In both the cases, section 29 was invoked against me.
Should we continue or should we break for lunch?
Continue on after lunch.
Okay. We'll break for lunch.
Okay.
Up to Your Lordship?
2:15.
2:15, Lordship.
If I may have Your Lordship's indulgence with us. There is one item for hearing, number 4. Item number 4, Miller. I was just discussing with my friend also. She's on the other side, Miller. We will file written submissions, Miller, because there are quite a number of factual aspects also. It might take a.
It will take some time.
But the matter has been heard.
It was heard in part now and then. In piecemeal basis. Then again,
it was heard before the original petitioner died.
Yes, Your Lordship. Once then again.
So we'll bring the thing so that on the particular day when it comes
We'll
out.
try and file it before the date fixed, and so that on the date fixed we can
short
give a
submission
summary.
Summary will do.
Summary of the thing. So if with Your Lordship's permission.
Then counsel for the petitioners, I have submitted that before this matter is orally heard, the parties may be allowed to file points of written argument for consideration. which sometime is paid for the same. On primary, the same is allowed. How long?
2 weeks time, Your Lordship.
3 weeks. 3 weeks.
This is matter to 3 weeks.
Pleasure.
All right.
I crave my lord's indulgence. Lord, item 9. The hearing list. Lord, the petitioner earlier, Ms. NG Sheila was there. Thereafter, I'm not sure whether any other councillor.
Lordship, on last occasion, I think Sheikh appeared, and he was thereafter again absent.
Oh.
So, my lord, I am praying that it's 2018 matter, my lord. Like that is why it's taking too long time for. I am due to the prolongedness. We are losing interest also in this matter.
What is the case about?
It's about school matters, appointment, teacher appointment.
Termination or?
Pardon, Lordship?
Is it termination?
Not termination, Lordship. It's appointment, and thereafter it's some sanctioned post is there. So the petitioner has to establish that whether it is a according to our contention, it is a non-sanctioned post. But then
Whether he is appointed? No, has he been appointed? Is he continuing?
No. Now the status petitioner can say petitioner can prove it. But then
See, if he has been appointed rightly or wrongly, and he continues in the post, then now you challenge, or maybe some order must have been passed. We don't know whether there's an interim order or not.
no, there is no interim order.
If that is the case, then his if it is termination, then his termination continues till today, until the matter is heard.
Lordship.
So it would be incumbent upon the petitioner to state his case.
To prove the case, but then petitioner is not.
Or else one date may be given.
Last chance may be
If they fail to
given,
appeal,
Lordship.
then it may be dismissed.
If they fail, then it can proceed and it may be dismissed. Because otherwise, how long 2018 matter, Lordship?
Petitioner is found to be absent. Respondents are present through their respective counsels. It is however submitted that the petitioner may be given another opportunity to be heard in this matter. Accordingly, this matter is adjourned. This is after 2 weeks. You can, talk to Mr. Sheikh, see if he's interested or not, or because last time he did, I recall.
Yes.
He has filed his power or something, or maybe he has
No,
not yet
he
filed his power.
took some time, Lordship. He sought some time
Because he
to
go
file
through
the
the.
power.
So we will have to give him chance. So 2 weeks then.
Lordship. Obliged.
Sure, pleasure. What after the findings on last time? Give a new finding.
Second call, item number 3.
Anything else, Mr. Rishi?
Lordship, one more just judgment. Because the accused person is there in the custody for more than 9 months, 3 days. The order have already relied upon that case cannot proceed it because FSL report yet to be filed and charge is yet to be framed and it is not proceeding. Lordship, 86 of the judgment Sutendra Kumar until versus CBI I have given in fact. It says that now we shall come to the category C, paragraph number 86, page 127. See that now we shall come to the category C. We do not wish to deal with the individual enactment as each special act has got an objective behind it, followed by the rigors imposed. The general principle governing delay would apply to those categories also. To make it clear, the provision contained in section 436A of the code would apply to the special act also in absence of any specific provision. For example, the rigors as provided under section 37 of the NDPS Act would not come in the way in such a case where we are dealing with the liberty of a person. We do feel that more rigors, the quicker the adjudication ought to be. After all, these type of cases, number of witnesses would be less and there may not be any justification for prolonging the trial. Perhaps there is a need to comply with the direction of this court to expedite the process and also stricter compliance of section 309. So it is distinguished that in the case of personal liberty of person comes, section 20, article 21, if there is a delay in the trial, then section 37 also Supreme Court will not be applicable because it pertains to the liberty of the persons. So, and there is some circulation in the same judgment. The Supreme Court has issued a circulation to each court. Here also category C. Category C says same as category BD with the additional condition of compliance with the provision of bail under NDPS Act NDPS Act 37, 45 PMLA, 211(6) Companies Act. Needless to say, the category A deals with both the police case and the complaint case. The trial court and the High Court will keep in mind the aforesaid guidelines while considering the bail application. The caveat which has been put by the learned ASG is that where the accused has been not cooperated in the investigation nor appeared before the investigation officer nor answered any summon, the court feels that judicial custody of the accused is necessary for the completion of the trial. While further investigation including the possibility of recovery is needed, the aforesaid approach cannot give them benefit. Something will agree. We also notice the aspect submitted by the Luthra while issuing notice to the Lordship, in fact, I didn't have only one copy. I'll just okay. Same until case is a case of until only.
You can expect me to.
Yes. I'll just supply the copy. Category C only. Category C. And the judgment which I am relying is a very recent judgment which I have already cited because of the. It also para 4 also deal with the personal liberty of the persons. Paragraph number 4 is I think. It is not here reported in the para 4.
Yes. What does it say?
It says about if there is a delay in proceeding with the trial, then the section 37 will not be at all a consideration.
So that is your main ground that there has been a delay.
9 months, 3 days is the delay. So I have 2 more judgment, Lordship, but this is maybe not applicable because it speaks about the 37 only.
Okay.
In this case, Supreme Court granted the bail, But that is the main ground, Lordship.
Anything else, Mr.?
May it please your Lordship. Lordship, kindly see the petition, the bail applicant here in your Lordship. She is a drug supplier, your Lordship. Earlier also she was arrested in a criminal, in an NDPS case, your Lordship, as stated in paragraph 3. So that means, your Lordship, in my humble and respectful submission, your Lordship, kindly come to page 3, paragraph 3, your Lordship, of the bail application.
Yes.
Kindly see, your Lordship, she was also involved in this case, which is pending before the learned Special Judge Long, your Lordship. So, in my humble and respectful submission, your Lordship, the bail applicant herein is a habitual offender, your Lordship, dealing in drugs, your Lordship. Then coming to this, to the case in hand, your Lordship, kindly see, as I pointed out, your Lordship, Lordship will kindly come again to paragraph 46 or page 46 of the bail application, your Lordship.
Yes.
The statement of Shri Kari Khar Nayor, your Lordship, and the statement of Shri Kemenlang Shabong, and the statement of accused Shri Marvin Jirwa, your Lordship, clearly, your Lordship, implicated that the bail applicant herein is a drug supplier. Is a drug supplier, your Lordship. Lordship, this statement, though may not be admissible for the purpose under the Indian Evidence Act, your Lordship, but in my humble and respectful submission, your Lordship, for the purpose of grant or refusal of bail, your Lordship, is relevant, your Lordship. So these three people, your Lordship, if Lordship I can come to page, if Lordship kindly come again to page 53. And 65, your Lordship. 53 and 65, your Lordship. See, your Lordship, they have implicated the accused, the bail applicant here in your Lordship. The name of the applicant is Kim Naikol Kongsa, your Lordship. What they mention is in the statement under 161, your Lordship, they say only a short name Kim, alias Didi. So, your Lordship, for the purpose of bail, your Lordship, in my humble and respectful submission, your Lordship, prima facie, the bail applicant herein is a habitual drug supplier, your Lordship. Then, Lordship, so far the statement made in 161, Lordship, I would like to interest. If Lordship kindly come from the first speech, Lordship, then Lordship, next, your Lordship. Next, your Lordship, towards the bottom, your Lordship, the High Court, Lordship has gotten. Next, and page 2, your Lordship, internal page 2.
Yes.
Then towards the bottom, your Lordship, the High Court, Lordship is with me.
Yes.
The High Court has ignored the material on record, including incriminating statement of witnesses under section 164-61 of the Code of Criminal Procedure. Statement may under section 161 of CRPC may not be admissible in but are relevant in concerning the prima facie case against the accused in application for grant of bail in case of grave offence, your Lordship. So, your Lordship, this statement, your Lordship. Then, so far, the contention that no recovery, your Lordship, I would like to rely. Mahmud Nawaz. Lordship, kindly come to paragraph 28-29. Your Lordship. as regard the finding, para 29, Your Lordship, Lordship at internal page. There is no page number. Para 28, Your Lordship.
Yes, please.
Lordship, as regard the finding of the High Court regarding absence of recovery of the contraband from the possession of the respondent, we know that in Union of India versus Ratan Malik, a two-judge bench of this court cancelled the bail on the accused and reversed the finding of the High Court, which had held that as the contraband was recovered from a specially made cavity above the cabin of the trunk, no contraband was found in possession of the accused. Then 29, in line with the decision of this court in Ratan Malik, we are of the view that the finding of the absence of possession of the contraband, on the contrary, on the person of the respondent by the High Court and impugn does not absolve it of the level of scrutiny required under section so and so of the NDPS. So, Your Lordship, it doesn't matter. So, in my understanding of this judgment, Your Lordship, it doesn't matter whether the contraband was recovered or not from the possession of the accused. Then, Lordship, for the moment, if Lordship kindly come to para 34 regarding the mobile number, Your Lordship.
Yes.
The following, Lordship, para 34. The following circumstances are crucial to assessing whether the High Court has correctly evaluated the application for bail having regard to the provision of Section 37. The respondent was traveling in a vehicle all the way from Nagaland. In the complaint notes that the CDR analysis of the mobile number used by the respondent indicate that was in regular touch with the other accused who were known to him. So, Your Lordship, is similarly, Your Lordship, is a case here, Your Lordship. They were in touch, Your Lordship. Then another contention, Your Lordship, is say that the mobile does not belong to me, Your Lordship. Lordship, if you are doing an illegal act, Your Lordship, a criminal act, Your Lordship, certainly, Your Lordship, I will not take the SIM in my name. I will not register the SIM card in my name, Your Lordship, because this is with the intention, Your Lordship, to commit something which is unlawful and illegal, Your Lordship. Whether that SIM belongs to the bail applicant or not, Your Lordship, in my humble and respectful submission, Your Lordship, these are to be tested in the course of the trial of the case. Then another contention, Your Lordship, that there is a delay in the trial, Your Lordship, in the case cited by my friend, Your Lordship. In my humble and respectful submission, that will not be applicable in the factual situation in this instant case, Your Lordship, because in that case there was a delay of more than 3 years. But, Your Lordship, here, Your Lordship, is only 9 months, Your Lordship. It is not so unreasonable, Your Lordship. It is a reasonable, Your Lordship, because of the peculiar situation, Your Lordship. So, my humble and respectful submission, Your Lordship, enlarging the bail applicant on bail in view of the fact that she is found involved earlier in 2019 supplying drugs and all, Your Lordship. In my humble and respectful submission, Your Lordship, if released on bail, Your Lordship, there is a reasonable apprehension and likelihood, Your Lordship, that she may commit against the crime, Your Lordship. As Your Lordship is aware that drugs, Your Lordship, murder, drug is the drug, murder, Your Lordship, a person kills one person only, but in drugs, Your Lordship, you kill 100 and 1,000 of people, Your Lordship. So, my humble and respectful submission, Your Lordship, let the trial go, let the bail applicant prove her innocence in the trial, Your Lordship.
What's my
then
submission?
Another aspect, Your Lordship, I forgot, Your Lordship. There is also that I made a submission that she is a habitual offender, Your Lordship. In fact, Your Lordship, I got one judgment from the Telangana High Court, Your Lordship. This is from Telangana High Court, Your Lordship, where the Honorable Telangana High Court has released a person on bail with certain condition, Your Lordship. With a certain condition, Your Lordship, but after releasing on bail, Your Lordship, she was the accused person was found to involve again in the Lordship. Then the bail, it was granted bail, and the state of Telangana filed a application for cancellation of bail. So the Honorable High Court, Your Lordship, found that he is a habitual offender. So the bail was accordingly cancelled, Your Lordship. This is from Telangana High Court, Your Lordship. But just
Lordship, all those judgments cited by senior counsel is not, in fact, not applicable in the instant case. What is my submission? I have narrated the facts, how I was arrested, implicated in the case. Section 29 is the only provision which has invoked against me. Now, I want to prove, I want to say that yes, I am not guilty or whatever evidence collected. But the problem, the delay of trial, Supreme Court does not say that 9 months is not a delay or 3 years is a delay. Delay is delay. Section 309 was already quoted. Section 309 said once the charge sheet is filed, it should proceed day to day. It should proceed day to day. In that event only I can prove my case. And until case, Supreme Court has said, power to postpone when in every inquiry or trial, the proceedings shall continue from day to day until all the witnesses attendance have been examined, unless the court finds the adjournment of same beyond following day to be necessary for the result to be recorded, provided when inquiry or trial relates to an offence under section. These are the provisions given, which judgment of in the case of judgment of Satyendra until also, Supreme Court said this is to be applicable under an NDPS Act. Now, since the Article 21 and 37, Article 21 is the personal liberty. The Supreme Court has distinguished that if the question comes for Article 21 of Constitution of India, then Section 337 will not be applicable. But if the liberty of the person to be restored under Article 21, not 37. So that is my case, Lordship.
Lordship, in reply to Lopan, Your Lordship, kindly see that the bail applicant was charged under Section 29. Section 29, Your Lordship, is abatement to criminal conspiracy. It says, Your Lordship, that in consequence of any abatement or imposition to certain, and notwithstanding anything contained of the Section 116 of the Indian Penal Code, be punishable with the punishment provided for the offence. What are the offence? What are the charges here, Your Lordship? Is Section 21C, Your Lordship. This is a punishment range from 10 to 20 years, Your Lordship. Kindly, Lordship, if Lordship is pleased. Then 22A, Your Lordship, this is 1 year. And 27A, Your Lordship, this is 1 year. So, Your Lordship, 21C, Your Lordship, the punishment, if they are found to have committed the offence, Your Lordship, then they will be subjected to punishment ranging from 10 to 20 years, Your Lordship.
But Lordship, at the same time, Section 54 of NDPS Act, it said, Supreme Court has said, I will cite a judgment in my petition only, if the recovery is not there from the persons, the presumption under Section 54 of NDPS will not be applicable. Even Section 37 or 35 also will not be applicable in the instant case. There is also one of the ground, but going too much on the details of the facts of the case, but only the court may take into consideration the Article 21 and 37 and judgment which I am relying upon.
Apply, Your Lordship.
Heard Mr. Qureshi, Learned Counsel for the petitioner. Also heard Mr. Andy Shulai, Learned AG for the state respondent. Excuse me. The Learned Counsel for the petitioner has submitted that this application for grant of bail under Section 439. I think I'll do one thing. I'll go through this judgment and pass this on.
Lordship.
I thought I'd
Ask
pass.
Lordship. Ask
My
Lordship.
throat is giving me a problem.
Lordship, would the influx of drugs in our state, Your Lordship? So I'm opposing each and every NDPS bill, Your Lordship.
I also know the drugs, but Lordship, the police and the government is not taking any preventive measures. They are just arresting the person possessing the drugs, and they conclude the investigation therein only. But they are not trying to expand the investigation, and no contact with the government of Meghalaya or Manipur. There is a lot of problem. The government is not doing anything, taking a preventive measures.
I'll pass this orders.
Oblige, Your Lordship.
Supplementary cost list, item number 1.
Yes.
Wait, please, Lordship.
Yes, who's submitting, Mr. Nupir or Mrs. Sheila?
Yes, Your Lordship, I'm
Yes,
submitting.
please tell me.
Lordship, this is an unfortunate case, Lordship, involving teenagers who are in a love relationship, and they have been dragged into a criminal proceedings, Your Lordship, for the very fact they were in love with one another. Lordship, here the petitioner is a 19 years old boy, Lordship. I have annexed the annexure 1, Your Lordship. I have annexed the birth certificate of the petitioner to show here in Your Lordship that the annexure 1 is the epic, annexure 2 is the birth certificate, Lordship, to show that he's a teenager
May please your lordship. My lord, this tender pertains to supply, installation, testing and commissioning, my lord. Commissioning of the lightning conductor system, my lord. And where they're supposed to be installed, they are all supposed to be installed in the defense establishments of the Assam Rifles, my lord. In Light Corps, then in the Nagaland, Assam, and 50% in Manipur, my lord, in various districts and establishments of the Assam Rifles, my lord. Now the tender was floated through GEM, my lord. That is the government e-marketplace, my lord. And the tender dated was of 27/06/2023, my lord. Now we are contractors, my lord, who has been supplying, who are expert in this field, my lord, in supply of electronic gadgets and other ancillary matters to the defense for the past 22-23 years, my lord. And we have got a good records as well, my lord. But not necessarily that I'm saying that I am asking for a tender through this court. I want to make myself very clear, my lord. Why I am before my lord is...
You cannot, in case, how can you?
My lord.
That would be for...
My lord, exactly, my lord. So, my lord, now, when we have gone through this tender documents, my lord, we have found various clauses, my lord.
Are you one of the bidders?
Yes, I am one of the bidders, my lord. We have found many clauses, my lord. Many clauses has been flouted, my lord. Guidelines have been diluted, my lord. Now, accordingly, now, the bid also provides that if any person who has got any objections or grievances against the bid document or against the bid, my lord. I'm just pointing out a page 34, my lord. Page 34 of the writ petition, my lord. Page 34 of the writ petition.
Yes.
The last, my lord, after what is written in Hindi, if you look from bottom, my lord, of just below point number 14, it starts with further.
Yes.
So it says, my lord, we need to submit our representations in case we have any objections or grievances, and they are bound to reply within 4 days. Until then, no bid should be allowed to open. So, my lord, we have pointed out in my page 35, my lord, that is the petition, that is the representations, my lord, grievances, in fact, that I have raised, my lord. I have pointed out at least 14 points, my lord, which I say that this bid is in total dilution, deviation from the guidelines, such like CVC guidelines and DRDO guidelines. This is what I have pointed out to them. And this letter was written by me on 01/07/2023, my lord. No reply. Within 4 days, they're supposed to reply to me this. No reply has come forward. And thereafter, my lord, by page 14 again on 03/07/2023. 40, page 40. Page 40, my lord.
Yes.
And in this, my lord, subject, what did I say, my lord? Very clearly I said, manipulated conditions and unfair selection process for GEM bid number so and so lighting conductor system. This is the subject itself I have raised. On 3rd, also I have written the letter, my lord. Then, my lord, again on by page 42, my lord, that is on 06/07/2023, my lord. Again I have written this letter, my lord. Now this is the 3rd letter, my lord. Nothing has come forward, my lord. Then after that, again by page 44, on 12th July 2023, I have again represented, my lord. So at least 4 letters I have represented, my lord. In this I have given very details, my lord. I will not like to bother, my lord, going through the letters, what is there, my lord. Now, my lord, on 18th, now failing, now the date was fixed for bid opening, it is drawing, my representations are not getting disposed of. So I made a mention on 18th and 19th the matter came up before justice, thank you, by mention memo, my lord. And on 19th, my lord, on 19th.
What happened on 18th?
On 18th, my lord, that was a mentioning date, my lord.
Okay.
And 19th, the matter was listed as a motion, my lord, before justice, before the other court, my lord. On 19th. Now on 19th, they have come up with a corrigendum, my lord. And where is that corrigendum? The corrigendum is at page 49, on 19th, my lord. And they have supplied this to me in the court, and also a copy was passed on to the court, my lord, as record. Now I took a day's time to get instruction because this is just been given to me as corrigendum. But in the corrigendum, my lord, out of 36 clauses, 22 conditions were amended, my lord. Now, my lord, I pose myself, when a tender is issued out of 36 conditions which has to be fulfilled by the bidders, my lord, I file a case, then 22 conditions get amended, my lord. That itself speaks volume, my lord. I need not elaborate much on that, my lord. Either that was defective or has been tailored, my lord, to favor somebody, my lord. So anyway, my lord, now on 20th when it came, my lord, 20th in the corrigendum itself also it says that again that same clause was there, that we can file our representations and within 4 days they will be bound to dispose of their representations. That is given again in page 58 of the corrigendum, my lord. Page 58.
Where is that?
The corrigendum is page 49, my lord.
Where is the communication that you can file?
That is page 58, my lord.
50?
58.
58?
58, my lord, 58. They said they can raise the representation against them by using representation window, providing the bid detail by seller dashboard after logging as a seller within 4 days. So I have filed my representations then and there. And then, my lord, when on 20th, when this matter came up before justice, before his lordship disposed of my writ petition, my lord. And in what manner my writ petition was disposed of, my lord, is at page 61, my lord. Page 61. Judgment and order, my lord. I'll just go straight to the operating part, my lord. From page 63, paragraph 5, my lord. Considering that a representation is in place against the bid details, which is yet to be considered, and the last date for submission of the bids being 31/07/2023, this court deems fit to close this writ petition at this stage to await the outcome of the representation. It is made clear that the said representation should be disposed of by 24/07/2023 to enable the writ petitioner to take further recourse in accordance with law if needed so arise. So there was a liberty, my lord. I have filed my representation. My representation against the corrigendum is at page 59, my lord. At page 59, my lord. 59, that is my.
Okay.
Now, my lord, 20.
When is page 59?
59, my lord, that is filed on 19th. 19 itself.
This order was passed on?
20th, my lord. The next day.
So this is not in response to this order.
My lord,
this order on 20th.
Yes, my lord.
Says that you can make representation.
No, my representation was pending.
Para 6.
Yes.
Pending.
Yes, yes. It says that because so 19th 19 they filed a corrigendum, 19 itself we have filed our, or 18 itself, 19 itself we have filed our representation. So when the matter came before his lordship on 20th we said that we have filed our representation. So the court says let's close this matter, but if you are still aggrieved, you can come back. So now my representation is page 59, my lord. Now this is important, my lord. 15, my lord, now as I said, 22 conditions have been changed. Had they changed one more conditions, then I'll have no case at all, my lord. And what was that condition, my lord? They say 2 years of experience, person who have got an experience of 2 years can also contest the beat, my lord. Now, my lord, this something which has been suppressed is this, my lord. Now this entire contract system, my lord, it's not only involve the supply, my lord. It involves supply, installation, and training, my lord. And 5 components are involved in that one, my lord. It's not only supply and you forget. So for this, a proper and experienced person is required. Why it is required? Because we are installing a conductor that will prevent lightning, my lord. That will prevent lightning in all the defense organizations, my lord. So my lord is aware, my lord, because of faulty or because of under quality, compromise in the quality of supplying and installation of this kind of how many accidents have caused, my lord. I can show, if my lord requires, my lord wants to see, I can show the newspaper clips where accidents have happened, my lord. And what are the panels or the findings, inquiries says, my lord. It's all because of the supply of the low quality done by inexperienced persons or the contractors, my lord. So this is the concern that we have been raising, my lord. Now even the GEM, my lord, CVC also says that this contract this bid has to be contested by equally experienced people, my lord. Now here, by changing 2 years of experience, they are allowing newcomers to come in also, my lord. Allowing the unequals, my lord, to contest as an equal, my lord. So that itself, it's not fairness to our fair competitions, my lord. So what I have done, my lord, here is page 59, my lord. I'll just take a little bit, my lord. It's just 8 paragraphs. What did I write, my lord, here? I said that we referenced subject representation for GEM number so and so, so it's a lighting conductor system. With reference to the above, we shall like to maintain the following. Point number 8, experience criteria. There are no experience criteria of the bidder. You have mentioned that the bidder or its OEM themselves or through resellers should have regularly mentioned and supply same or similar category products of any central or state government organization, public listed company for 2 years before the bid opening. You will notice that this is a condition of GEM for suppliers and retailers. While your project is of supply, installation, testing, and commissioning, so installation of equipment is important parameters, and that you have conveniently ignored because your favorite bidder does not have any experience, and under instructions of your senior complete Assam Rifles is banned to mend the rules and give him order. For your information, DRDO Procurement Manual of 2020 and CVC both specifies a condition that bidder should have done 80% of 1 work, 50% of 2 work, and 40% of 3 work. You are not following this clause for the reasons explained above. Kindly amend the condition of the bidder's eligibility. Now, by my lord.
Before we proceed.
Yes, my lord.
This is the representation you have filed on
19th, my lord. Yes, my lord.
So this require response.
No, this has been responded to us responded to us, my lord, by by
Okay,
page
okay,
64, my lord.
In spite of in
Yes.
that, in that response, that condition has been put
Not
in.
amended. Not amended. That is why, my lord, we are before your lordship. So, my lord, in point number 8, my lord, when we go back to the where is that criteria?
So your main grievance,
Yes.
would be that because of the condition put in
Yes,
by
my
the
lord.
bidder, that they
By,
should be
by the
by
respondents, my
by the
lord.
respondents, sorry.
Yes, my lord.
That even if a contractor or any party who has 2 years qualification,
Yes.
2 years experience,
2 years experience.
he can still contest the bid. So that according to you cannot be contemplated.
Yes, that cannot be contemplated because what happens is,
Because
my
of
lord. Yes.
the
And-
sensitivity and the
Yes.
technicality of the
Yes, my lord.
issue.
And my lord, and then my lord, here in the point number 8, when they ask for the experience certificate, my lord,
Excuse me.
they say 2 years, my lord. The 2 years is only a supply, my lord. And CVC and the other guidelines says because their bid is not only for supply. Had it been just supply and forget it, whatever you have to do, you do it, then that's a different issue. But here it involves 5 components, which I have just read out. Supply is one, installation, testing, and commissioning, my lord. So this is one of the this, my lord, which they have not adhered to, my lord. And also, my lord, they have diluted now. It says that 80% work, they have made it to 20% work, my lord. That is another dilution, my lord. Now, my lord, now what did they reply to us?
But you can show where is the 20%, my lord? This is submission without anything on record, my lord.
My lord, I'll show that also. What did they reply, my lord? 20%, my lord, earnest money, my lord. Can you look at the contract itself, my lord, the bid itself, my lord?
EMD is something different from EMD turnover.
Page?
My lord, can you come to page 64, my lord? First, I like to place the case, my lord, where 64 the experience part is concerned, my lord. Page 64, this is what they have replied to me, my lord, against my representation, my lord. It says, the product lightning conductor is a generic technology and does not require any special skills for installation and commissioning. They say generic, my lord. By using the word generic, they want to dilute the entire thing, my lord. Generic means just a supply, my lord. And they are themselves saying that installation, it does not require special skills for installation and commissioning, my lord. My lord, the CVC guidelines, my lord, which I have filed in my additional affidavit, my lord, that is at page number 4, my lord. How they are trying to dilute this one by saying that this does not require any special skills, and by terming as a generic, my lord. Now this is the CVC guidelines. CVC guidelines says page number 6, my lord. I'd like to point out page number 6, my lord. Number A, for civil electrical works, my lord. My lord has got?
Yes.
It says average annual financial turnover during the last 3 years ending 31st March of the previous financial year should be at least 30% of the estimated cost. Number 2, experience of having successfully completed similar works during the last 7 years.
ending last date of the month of the previous to the one in which applications are invited should be either of the following: 3 similar completed works costing not less than the amount equal to 40% of the estimated cost, or 2 similar completed works costing not less than amount equal to 50% of the estimated cost, my lord. Or 1 similar completed works costing not less than an amount equal to 80% of the estimated works. So, my lord, here 7 years of experience, they said 80% work, 40% work, and 50% work, they said. Where is that criteria? The respondents like to put a question to me to answer. Where is that 20% work which I'm saying? Where is that clause where you have where you have given a conditions of these criterias in the bid? This is where I was saying, my lord, this has been authored perhaps to help some players who are a newcomer, who are not experienced. And my lord, kindly look at the Defense R&D Organization, DRDO's procurement manual also, my lord. That is at page 8 of my additional affidavit, my lord. Page 9 talks about pre-qualification of vendors, my lord. Pre-qualifications. It says, pre-qualification is a useful method of gaining knowledge of prospective bidders and reduces costs and risks for both buyers and sellers. Realization of high-end technology equipment, turnkey contracts requiring multidisciplinary expertise of the bidders at times involves in part or full activities of detailed engineering, procurement, subcontracting, inspection, transportation, erection, and commissioning. In such case, a contractor is expected to coordinate all the activities and supply the item, equipment, complete an erection, commissioning, and hand over the facility to the lab. Such bidders are required to possess necessary technical and organization skills, financial capabilities, my lord. Now, by this bid, what they're trying to dilute is, my lord, by saying that this is only a generic, it's okay. But, my lord, this is something which an expert requires, my lord. We have seen whatever the High Court, my lord, here, those conductor that has put it, these are not very highly technical things, my lord. This can cover only 1 meter, 1 meter. That's why, actually, why one is there in that auditorium, my lord, on top. Because it comes only 1 meter distance that get captured, my lord, and can push it down to the earth, my lord. But here they're talking about, my lord, the supply of something, because in the defense establishment, where they'll be establishing in where they are installing the arms and ammunitions, my lord. So person who are an expert in these fields are required, my lord. So they are saying that you don't need, you just need to go and install it. That is not correct, my lord. And my lord, and also, my lord, page number 10 also, my lord. Page number 10 of this DRDO procurement manual also, my lord. It says 3.13 types of stores and criteria for pre-qualifications, my lord. Pre-qualification may be resorted to for acquisition, development of major plants and machinery, complex information technology system, medical equipment, sophisticated weapon system, telecom equipment, high-end software, and development of other special goods. In these cases, well-defined procedure should be followed for the pre-qualifications of vendors. While doing so, wide publicity would be given through print and electronic media. Pre-qualification, so my lord, all these things we will go, and then see, kindly look at what we are supposed to see. Experience, Roman number, experience and past performance on similar contracts, my lord. Similar contracts. Now, what did they say? In fact, my lord, they said 2 years. They have done exemptions. They have exempted everything. I can show that one. If my lord comes back for a moment to the bid at page number 19, my lord. Page number 19, my lord. of the main petition, I'm sorry.
Yes.
My lord, 1, 2, 3. 3, the third column from the bottom, my lord. Third column from the bottom, page 19, my lord. What it says? The third row, sorry, the third row. Years of past experience required for same similar service. They said 2 years. MES exemption for years of experience and turnover. Now they have given an exemption. They said, yes, we are giving an exemption. And they said, startup exemption for years of experience and turnover. We are saying, yes. And another thing, my lord, is it may not be very significant, my lord, but it might make some impact here, my lord. Now, my lord, this kind of system, my lord, when I said I have been supplying for the past 23 years, my lord, because of the COVID situations, my lord, this kind of supplies have not been undertaken, my lord. So now you are asking 2 years of the past experience. Somebody who has no experience, from where do you give? So that is why the requirement of 7 years experience, my lord, it will be fair. It will seem to be fair. Then I have no problem. Because if I am competing with somebody who is having an equal experience with me, I have no problem. But the problem here is a person who has no experience at all, you are allowing him to come and compete. Seemingly you are going to give a job to him. That is the problem where I have. And that is where I said that there is no fairness in the competition. Otherwise, I have no business to be before this honorable court for the judicial review of all these orders and the bids that have been passed by an authority which is covered under Article 12, my lord. Otherwise, I have no business, my lord. Now, my lord, have seen this also, my lord. Now, then page 10, my lord, with reference to personal equipment, manufacturing facilities, financial standing, all this. Another one that I would like to show, my lord, where I said, now this is the page 13, my lord. Page 13, this is the manual for procurement of goods, updated June 2022, my lord. Government of India, Ministry of Finance, this is passed by them. And my lord, page 14, my lord. Again, here also they talk about pre-qualification bidding. What they talk about here is, in complex technical requirements where capability of sources of supply is crucial, for example, in procurement of complex machinery and equipments, for the successful performance of the contract, besides considering techno-commercial suitability, it is necessary to ensure that competition is among the bidders with requisite capabilities matching the challenges of the task. In case bidders with inadequate capability are allowed to compete, the better qualified bidders would be eliminated, since their bid price is likely to be higher, commensurate with their higher capability infrastructure. Such situation, a separate stage of P and PQB bidding system may be considered. Now, my lord, where the requirement of technical. So, my lord, here also, my lord, now another point that I wanted to show, my lord. They said it's a generic. When they say it's a generic, my lord, and they said we don't need an expert in doing this, my lord, it means, what do they mean to say? They mean to say is, okay, just supply. This is what they want to impress upon all. But what is there, my lord? Now, but what is exactly that? Just to differentiate, my lord, and just to expose, my lord, page 15, my lord. Page 15, my lord, this is the general specification for electrical works, my lord. This is CPWD's manual, my lord. Chapter 9, my lord, page 16. What are the principal components, my lord? The principal components of a lighting protective system are air terminations, down conductors, joint and bones, testing joints, earth terminations, and earth electrodes. The materials of air termination, down conductors, are etc. of the protective system shall be reliably resistant to corrosion and or be adequately protected against corrosion. The material shall be of the following specific, so and so forth. Now, this, what we are talking about is a protective system, my lord. It is not as easy as saying the generic and you just supply and you go. The lowest bidder will supply and he will go. It is not. We are talking about the entire protective system, my lord. So therefore, my lord, this bid, my lord, being a deviation of all the guidelines, my lord, should be stayed, my lord, till final hearing on the merits, my lord. We have lots of documents to show, my lord. And my lord, now another thing that they have said, that in the past also we have contested in under the same terms and conditions, my lord. That case, in fact, my lord, they said for the technical reasons. So that even in that time also, my lord, this honorable court had stayed. In the case of Manmohan Singh, my lord, initially the tender was stayed, but subsequently, for good reasons, it was withdrawn, my lord. But initially, it was stayed, my lord. I have annexed that order also here, my lord. Yes. And that order was passed by Justice Thank You himself. Page number 8, my lord. Page annexure 8, page 92, my lord. Additional affidavit, my lord. And in that case also, my lord, the government, the respondents were represented by the learned ASG, my lord. May I read out very quickly this Manmohan Singh's case, my lord. Heard Mr. P. N. Nongbre, learned counsel for the petitioner, on a prayer for stay of tender process in connection to 1921. Dr. So-and-so, counsel for respect press that he may be allowed to obtain instructions to apprise the court on the next date. Prayer is allowed. In the interim, the tender process in question shall be kept in abeyance until the next date, my lord. So, my lord, what I'm asking here also, my lord, today is the bid day of opening, my lord. My lord may be pleased to stay that bid for a week or so, my lord, till let the proper response come, my lord. In a week's time, nothing is going to happen, my lord. If they don't open also, nothing is going to happen, my lord. Let us hear on merit, my lord. That is all, my lord.
I think the entire merit is already disclosed, my lord.
Sorry. It's easier for you to respond.
There are two types of contracts in government, my lord. One is procurement of goods and one is construction work, my lord. And for these, there are two separate manuals issued by the Ministry of Finance, my lord. The Assam Rifles is bound by those manuals, my lord. One is called, my lord, Manual for Procurement of Goods. The other one is called, my lord, Manual for Procurement of Works, my lord. So works will deal with construction activity, my lord. And now there are two separate websites, my lord. Nowadays everything is online. When we are purchasing goods, my lord, then for that there is a GEM portal, my lord. It is something like Amazon or Flipkart, my lord. And for works, my lord, there is a separate website called eprocure.gov.in. So for construction contract, the tender has to be floated through eprocure.gov, my lord. For goods, it is through GEM portal, my lord. Now in the instant case, my lord, what we are planning to buy is a system, my lord, which is four parts, my lord. One is some kind of antenna on the rooftop. There is a wire which connects that antenna to ground, and there are some electrodes are there which is to be installed in the underground, my lord, so that any lightning can be conducted to the ground, my lord. Now, my lord, the same manual says, because nowadays what happens, my lord, even if you buy a TV, my lord, TV cannot be a works contract, my lord. TV is definitely a goods. But when we buy a TV, we tell them, the shopkeeper, that please come and install it. We buy a Tata Sky, my lord. They come and install it for generator, for solar panels, solar water heater, all these kind of things, my lord. So that is why the manual itself makes a provision that ancillary installation works will not change the nature of that. It will still remain procurement of goods only. It will not become procurement of work, my lord. Because more or less everything nowadays requires some kind of installation, my lord. If I may just point out that particular definition, my lord, in the goods definition. My lord, the manual itself says, my lord, procurement of goods may include certain works or some services which are incidental or consequential to the supply of such goods, such as transportation, insurance, installation, commissioning, training, and maintenance. So these can still be procurement of goods only, my lord. Now, my lord, now these, as I submitted that altogether different websites, different manual for them, my lord, and the experience criteria required are also different, my lord. Because in construction contract manual, there is a question of running account payment, running bills, and many other things are involved. So criteria are altogether different. What my friend was referring to, 70% and 40%, my lord, your lordship, if I may just take your lordship to that particular page, my lord, in the writ petition. Page 6 of the additional affidavit, my lord. My friend has read for civil electrical works, my lord, at page 6.
Yes.
My friend has referred to, now the heading itself is civil electrical works, my lord. So, means construction work, my lord. There the requirements are 7 years, 3 similar completed works of 40%, 2 works of 50%, 1 work of 80%. My friend has not referred to the clause B, my lord. My lord, this pertains to 4 store purchase contracts. We fall in this, my lord. Here the requirement is, my lord, if I may just read few lines, my lord. Pre-qualification, post-qualification shall be based entirely upon the capability and resources of prospective bidders to perform the particular contract satisfactorily, take into account their experience and past performance on similar contracts for 2 years. This is exactly what we have put in the tender condition, my lord. That experience of similar contracts in last 2 years. My lord, this requirement is a standard requirement of Assam Rifles, my lord. I'll place several others, my lord, where in each and every tender the requirement was 2 years experience, my lord, for purchase contracts, my lord.
Where is the indication in this particular contract which says that, or this particular tender?
2 years, my lord.
No, where does it say that it is a purchase?
Yes, because it is uploaded in GEM portal, my lord. That itself is a proof that it is a.
Okay, so GEMs means.
GEM is only for goods, my lord.
For goods. Okay, and e-procurement means
for contracts, my lord. My lord, page 19 will indicate, my lord, GEM is mentioned there. Page 19 of the writ petition, my lord.
Yes, yes.
GEM is very clearly, it is uploaded on GEM, my lord. This is an undisputed fact, my lord. Now, my lord, I placed 3 other tenders, my lord, issued by Assam Rifles. Second page, your lordships will see in each of these 3 contracts. One is for generator, one is for similar kind of things, my lord, where some minor installation, other things are there. The requirement is a 2 years experience, my lord. So much so, my lord, the earlier in 2021, the same tender was issued, my lord. Even in that, the condition was 2 years experience, and there he participated, my lord. For some technical reason, that tender was ultimately cancelled. The writ petition, which my friend is referred to, stay was granted. That was withdrawn subsequently, my lord. No judgment was passed in that, my lord. So, my lord, to say that this tender is tailor-made, my lord, is absolutely incorrect, because the CVC guideline itself says that it should be 2 years. I've shown that other tenders we are putting a standard condition that it should be 2 years. On what basis the writ petitioner is saying, my lord, that this tender is tailor-made for a particular bidder? Moreover, my lord, your lordship, I'll place the thing from a different perspective. By putting a higher criteria, my lord, we restrict the competition, my lord. If we say that somebody must have 10 years experience in supplying this lighting system, my lord, maybe we'll get only 1 or 2 in the entire country, my lord. But we put it 2 years. The basic idea is to give fair competition chance to everybody to compete. If we keep a threshold so high, my lord, what happens ultimately, my lord? Only few people will monopolize, and that is what exactly they want, my lord. They want it to be 4 years or 7 years, my lord. What will happen? Only they will be the prospective bidders, all others will be. Well, it is something like putting for a steno's post, my lord, 90% marks is required in class 10, my lord. If that is so, my lord, that can be said that it is tailor-made for somebody, my lord. Here is a reverse situation, my lord. Here it is not tailor-made, because here we have reduced it so that there is a fair participation, there is broader participation by everyone, my lord. My lord, the whole idea of filing the writ petition, my lord, 4 years back they supplied, my lord, that time we had a requirement, because Assam Rifles is ammunition depot, my lord, all over the places, and transformers, my lord, electrical transformers, they're like magnet to lightning, my lord. For that purpose, because there are 3 types of lightning conductor system available now, my lord, broadly. One is a very high one which they supply, my lord. This is called piezoelectric technology. This is a French technology. The cost of one lightning conductor is 40 lakh rupees, my lord. Second one is what we are, and third one which we see in the High Court building also, in the other residential building, those are very, maybe 10-20,000 rupees or 50,000 lightning system. Now, my lord, that time we had the requirement of protecting ammunition dumps, transformers and vital installations, my lord. So that time we went for the high-tech ones, because here what happens, my lord, what is the difference in the technology? These high technology ones, they foresee that lightning is going to come. They call it 60 microseconds, 100 microseconds before actually the lightning strikes, my lord. They get activated that time only, and they absorb it, my lord. The second one, that time is little less, my lord. So you get a longer time before lightning is supposed to be more safe. But the cost factor also has to be taken into account, my lord. Those were 40 lakh rupees per system, my lord. Here we are buying something around 3.5 or 4 lakh rupees, my lord. And even the ordinary ones, we are not going for that. Now here, in this tender, my lord, we are buying this for residential buildings, my lord. Not for ammunition dump or for transformers, my lord. Because there are lightning prone areas in Northeast, my lord. So it was a decision taken that will protect our buildings. Because some office complexes, because computers are there, and some secret information are there, and other things are there. So they are meant for that purpose, my lord. Now, all our internal guidelines, my lord, our Assam Rifles procurement guidelines very specifically lay down, my lord, that threshold should not be kept very high so as to restrict the competition. Threshold should be reasonable. And in case of supply of goods, it should be 2 years, my lord. That is the standard. I can place several other documents, my lord. So, my lord, in my humble submission, there is absolutely no merit, my lord. Their whole interest, my lord, is to frustrate this contract. They want a 7 years condition, so that what will happen? We are forced to buy that 40 lakh rupees system, my lord, from them. My lord, at that time, we bought 40 systems from them, my lord, from the same contractor, at about 12 crore rupees, my lord. Now, for about 7-8 crore rupees, we are planning to buy 200 systems, my lord. So, my lord, when I need a bicycle, my lord, who can force me to buy a motorcycle, my lord? My requirement is bicycle, I'll buy bicycle. And for bicycle, I'll go to bicycle shop, I'll not go to a motorcycle showroom, my lord. So, my lord, in my humble submission, there is absolutely no merit in the case, my lord. They came, and that much liberty was only given to them because the earlier round elaborate hearing took place, my lord. This honorable court was not satisfied. Only that much leeway was given to them. Since you have submitted a representation, they will dispose of the representation. My lord, they cannot point out a single anomaly. Every question which they posed before us have been answered, my lord. My lord, one last submission, my lord. My friend submitted that there are 22 clauses changed, my lord, in the corrigendum, my lord. And that speaks volume about the entire process. Now, my lord, a tender document talks about something. My lord, for example, there is a book. In the book, the main actor's name, for example, was Mr. X, but by mistake it is come as Mr. Y, my lord. So that has to be corrected in every place, my lord. So if in that book that name is there at 10 places, my lord, so that is how only 2 or 3 changes were made, that also on their request. One of the conditions, my lord, which was changed was that site visit tender provided that the bidders would go and visit the site, see the conditions. All the conditions, because mostly they are Manipur. Their grievance was that Manipur situation is not good, it is not possible to travel to Manipur. So we thought it reasonable. So we relaxed that criteria that you visit only 50% of the site, excluding Manipur, that also. So you don't need to go to Manipur, law and order is not good. Now, my lord, to make that change, you have to make changes in 2-3 places. Similarly, some wire, my lord, 75 mm, 50 mm, some changes were required. I can show that, my lord, in the corrigendum itself. Same thing is repeated, so it doesn't make 22 changes, my lord. These are basically 2 or 3 or 4 changes, my lord, which are repeated because they find mentioned in different pages of the tender, my lord. So, my lord, the due date for opening tender is today, my lord. These are vital installations, my lord, and already been delayed, my lord.
But you are also one of the bidders.
My lord, I have to take, but
well, if you are one of the bidders, then you may be considered.
My lord, it's not that we wanted 7 years, so that the criteria has to be 7 years, my lord. It's not that. But the guidelines provide a 7 years. This is what we are trying to point it out, my lord. CPWD norms, my lord, I can point it out from here. At least 2 documents, my lord.
CPWD is not applicable to. We go by the procurement of.
Now, what has been explained,
my lord,
is that there are 2 parts to the whole procurement process.
My lord.
That is for works, electrical work, or
yes,
works or civil work, whatever the case may
my
be.
lord.
And the other is for purchase.
My lord.
So, if yours comes within germ, which is for purchase.
My lord. My lord, that is the whole idea, my lord.
So we are not talking about the quality of the material purchase.
My lord.
If it is for installation or for works,
my lord,
then if a construction has to be made,
my lord,
quality has to be looked into.
My lord.
But not for purchase.
My lord, that is where the entire concept is coming, my lord. This is not only a they are trying to make it as a procurement, my lord. It's not only a procurement, my lord. It isn't installations, my lord. It's a commissioning, my lord.
Yeah, that's what you said.
My lord. These are the things. And even CPWD, my lord, kindly have a look at this for a moment, my lord, page 49, my lord. Page 49, my lord. This is a standard that has to be followed. Assam Rifle can't have a different standard, my lord, when the same risk is involved, my lord. Lightning will not recognize which one is Assam Rifle establishment or which one is the High Court. It will fall equally. Therefore, the standard has to be uniform, my lord. CPWD page 49, my lord. It says, my lord, specialized agency dealing in the field of supplying, installation, testing, commissioning of audio video system, my lord. This only is of audio video system, my lord. Here we are talking about a lightning system to control the lightning system, my lord. Now, my lord, with the experience that is required, my lord has got page 49.
49,
page 49,
instruction.
My lord. Information and instruction for e-tendering, my lord. E-tendering. So, that is what I've just read out, my lord, in the bold marks, my lord. And contractors, my lord, kindly look at the clause 1. Contractors who fulfill the following requirements shall be eligible to apply. Joint ventures are not accepted. Number A, should have satisfactorily completed the works as mentioned below during the last 7 years ending on the last date of previous month of the last date of submission of the bids, my lord. They said 2 years of experience. Here they are saying 7 years of experience, my lord. Now, my lord, another.
But 2 years. My lord, this tender itself is for renovation of the conference hall, my lord. This is a construction work, my lord.
You are referring 2 years is you are referring from a manual. Yes, that manual is not
in their petition only, my lord. In the supplementary affidavit, my lord. At page 6, my lord. Page 6, on top is for civil electrical works and below is for store purchase contracts. 2 years very clearly mentioned, my lord. In the very document they are referring to, my lord. And I pointed out 3 more contracts. I can place 10 more contracts, my lord, where 2 years is the standard contract for Assam Rifle in all these cases, my lord. My lord, I've been told to apprise this honorable court. The one disturbing thing is happening, my lord. I don't know whether my friend is aware. He is going and threatening Assam Rifle officers, my lord.
Oh, that I'm not.
That he'll go to CBI and do all kind of things, my lord.
That I have no.
On the one hand, they are filing a writ petition before this honorable court, my lord. This is the instruction I specifically received, my lord. That he is going and threatening that he'll go to CBI and he'll go to Prime Minister. He is free to do, my lord, whatever.
That I have no instructions.
When he filed a writ petition before this honorable court, my lord, at least he should desist from doing all those things, my lord.
Then more so let him come in the affidavit, my lord, because I have no instructions, my lord. I have absolutely no instruction. I'm not aware of what the respondents are saying at all, my lord.
Oh, in that case, I think that would be, of course, like we said, we don't know. Prime facie, we don't know.
My lord.
But that would be using of coercive.
My lord. Yes, my lord.
So come to the court with clean hands, my lord.
Well, that I have absolutely, my lord. They're just saying whatever they're saying. What I have no absolutely idea about what they're saying, my lord.
They can come with it. They have not filed there.
Yes, let them file. That's what I'm saying.
Moreover, my lord, I'll place one letter, my lord. What he has done. The owner of this firm, my lord, he is formed in association, my lord, in Delhi. Address of the association is same as his own office address, my lord. Even before the tender was issued, my lord, he wrote a 2-page representation to the Director General that you don't buy this equipment, you buy the 40 lakh rupees one, my lord, because that is very highly efficient, this, that. Well, the whole idea of this person, my lord, of the writ petitioner is to force us, my lord, to buy something which we don't require for our residential building, my lord. And for that, they're using all kind of pressure, my lord.
My lord, nothing is on report before my lords.
Yes.
Let it come by way of an affidavit, my lord. We will respond to it because now allegations are coming, my lords. Personal allegations are coming, my lord. For the interests of natural justice, my lord, I must defend myself, my lord.
Yes.
Let him come by way of an affidavit, my lord. Let it be 5 days. Let it be 5 days, my lord. 5 days. Let them hold it for 5 days, my lord. We will do it, my lord. If I lose, I lose.
But stay, this is not a case of stay, my lord.
My lord, then the entire thing becomes infractious.
My lord, stay can only be granted when essential 3 prima facie case, balance of convenience, and irreparable law. I don't think my friend has been able to make out even a prima facie case, my lord. Now, balance of convenience is again another aspect. Irreparable loss and injury, my lord. He has not met out as
my lord,
any case, my lord, for stay.
My lord, when I have been able to show, my lord, when the CVC guidelines, DRDO guidelines has been floated, my lord.
This is
floated.
the CVC guideline,
and my lord, interestingly, my lord,
page 6 is the CVC guideline, my lord, which says 2 years, my lord.
Interestingly, my lord, can you look at this conduct, my lord? 4 days they're supposed to reply to my representations, they slept over. 4 letters were written, they slept over. The day when I came to this honorable court to get my grievances redressed, immediately they file a corrigan now, saying that 22.
My lord, I need to answer that, my lord.
They're saying that 22 clauses have been changed. Now they're saying that it's only the corrections. They're saying only a corrections, my lord.
I need to answer that, my lord, because this is a very wild allegations they're putting, my lord. My lord, kindly come to page 34 of the writ petition, my lord.
$30?
34, my lord. This is the tender, my lord. My lord, after clause 14, my lord, my friend has referred to this, my lord. But my friend did not read it fully, my lord. It says, my lord, further, if any seller has any objection, grievance against these additional clauses or otherwise on any aspect of this bid, they can raise their representation against the same by using the representation window. Lordship got it?
Yes, yes.
In the bid details filled in seller dashboard after logging in as a seller within 4 days of the bid publication on GEM. My lord, the representation has to be submitted through bid portal only, my lord. I asked a question to the writ petitioner, have they done so, my lord? But the representation has to be through the GEM portal itself. There is a window, my lord. You have any objection, you write there. They have not done so, my lord. In spite of that, my lord, when the matter was listed, the earlier matter, my lord, we undertook to respond to that within 4 days, my lord, and we responded to that, my lord, by 24th.
See, the fact remains
Yes.
that there are allegation,
my lord,
and counter allegation.
Yes, exactly, my lord.
They have to be.
Yes, my lord. Let them file.
File affidavit, there is absolutely no problem, my lord. But my lord, in my ombudsman stay, this is not a case for stay, my lord.
So, suppose,
my lord,
let's put it this way. See, I have very little experience in these matters.
My lord.
Suppose if we allow the the
bids to be opened.
Can it be reversed later?
No, it can't.
On finding on a finding by this court to
anything is subject to outcome of the writ petition, my lord. But my lord,
yes, we can do that.
My lord, my submission, my lord, is
my lord, I am agreeable to that one, my lord. Yes.
My lord, if at the threshold he cannot make out any case, my lord.
Yes, my lord.
Muzika, the point remains that I've heard the matter. I've considered both aspects of both sides of the both sides of the coin.
My lord.
But the fact remains that, as you have rightly pointed out, these are all submission on the merits of the case.
Yes.
That has to be, finally has to be, every point has to be taken into consideration.
My lord.
Has to be answered.
My lord.
Has to be, duly countered.
Yes.
So what we can do at present, as has been submitted, if that is the case, the bid will continue.
My lord. Work order subject to the outcome of the writ petition. My lord, I'm agreeable to that.
You have a case.
My lord, I'm agreeable to that, my lord.
We will be free to go ahead with the bid, minute.
Yes.
My lord. Subject to the outcome of the writ.
Subject to outcome.
My lord, I'm agreeable to that.
Otherwise, your writ then becomes infructuous.
Infructuous, my lord. I'm agreeable to that, my lord. I'm grateful.
But
my lord.
I am not one to see it without first considering all aspects.
Let them come, my lord. Allegations are there.
Allegations, they come up with any kind of allegations, my lord. In my humble submission, 226 court is not required to look into those allegations.
As far as tender matters are concerned, you know very well.
My lord.
Tata Cell case is there.
My lord.
Heard Mr. P.O. Leonard Counsel by Petitioner. Also heard Dr. N. Muzika, Leonard DSGI, appearing for this respondent, Union of India. An elaborate argument has been made on both sides. However, the argument has almost touched the merits of the case. It may be reminded that the counter affidavit have not yet been filed by the respondents, and as such, readings are not yet completed. The limited prayer of the petitioner at this point of time is for a stay of the bidding process, or do they call it?
Opening of the bid, my lord.
Opening of the bid.
Scheduled for today.
Which is scheduled for
31st.
That is 31st
July.
As far as, what is the bid number?
Just the bid number is my lord, it is GEM capital slash 2023 slash B
page 19
page slash 3622434 dated 27/06/2023. 2023, and a corrigendum also is there.
Corrigendum will automatically come.
Corrigendum. Yes.
Next, this court would not dwell into the merits of the submission made, but would, however, direct that the opening of the bid, which is fixed today, shall not be in any way hampered or stayed. It is, however, made clear that the final outcome of the tender process would be subject to the disposal of this petition.
We'll file affidavit in 1 week's time.
As prayed for, counter affidavit we file within 1 week's time. List the matter thereafter.
My lord. Obliged.
Because of my throat problem, I don't want to give a long dictation.
That's good enough.